so that we kick off in earnest. And in doing so, I will be introducing our speakers and the moderator that will take it up from here going forward. So the moderator rather, will be in person of Stella Thomas. Stella Thomas is actually the COO of Raven Marketplace. She is also a young lawyer in the Gariki branch. So also we have speakers, well-seasoned speakers in the field we have chosen to speak on the topic we have chosen to speak on today. We have first and foremost Mr. Olaoluwa Ario, who is actually a partner in More and More Attorneys, a top law firm in the city of Abuja. We also have joining us the SWAL chairman of the MBA Sabama branch, which is in Port Harcourt, in person of Mr. Igbombo Araboma. I appreciate you all for coming and we'll be kicking in earnest. At this point in time, I'll be handing over to the moderator who will take us from here in person of Ms. Stella Thomas. Stella, are you with us?
Sorry, what's the name of the person speaking so I can allow the person on mute? Who is supposed to speak now?
Okay, that's Stella Thomas.
Okay, let me check if she's online.
Yeah, she is.
Okay, so Stella is now a co-host. Stella, you can unmute yourself and speak.
Hello everyone, can you guys hear me?
Yes.
Right, thank you so much, Mr. Justice Oga, for that warm welcome. Okay, so without further ado, we'll just dive straight into the matter of today and invite our first speaker to give us the first session of the day. So permit me to welcome the first speaker in the person of Mr. Ibongo Paraboma, the former chairperson of NBA Sagama branch, to give us the first session on the topic effective research and drafting. I don't know if Mr. Paraboma is here. So Mr. Paraboma will be giving us our first talk on effective research and drafting. As we know, drafting skills is very essential in the life of a legal practitioner, and it's something that we must continually sharpen and get better at. And I mean, we're in the times of AI and so many innovations. So we need to keep learning and sharpening these skills. So if Mr. Paraboma is here, I would appreciate if we unmute him to start his session.
Okay, it appears he is having a hard time connecting at the moment. So, suggest would suggest, okay, I think it's on now.
Yeah, I think he's trying to share his screen. All right,
Okay,
thank you, Mr. Brown. You're
I'm
welcome.
here now. Can I go ahead, please? Can you guys hear me?
Yes, sir. Yes, sir.
Okay. Good afternoon, ladies and gentlemen. My name is Igbongbo Paraboma Nelson. I have very limited time, so I will just go right away. Effective research and legal drafting. Now, the word research has two words joined together. Read and search to get information, seeking for information. That is what research is about. Now, when you want to talk about research, it is just a step ahead. Research simply means not just finding, but the skill, the analysis, the approach that you adopt in finding the information. I repeat, research has a bit more of an extra. You are first of all finding information, which is search. Research means that you are taking a step further in ensuring that you get proper information. What you're doing at that point is a systematic investigation into already existing materials. That means you are going deep to find out information systematically, painstakingly into materials, legal documents, laws, precedents, case laws that are already in existence. Why do you do research? It's because you want to come to a particular conclusion, and you just don't want to conclude on the basis of hearsay or any other person's information. You want to collate facts from already existing materials. If you observe today, even judges have research assistants. That means people who help them find what they want. You know, we're taught that in law, that a lawyer needn't know the law, but where to find it when he needs it. That is what research does for you. So for you to do a proper research, you have to do a painstaking, studious inquiry into facts. These are not non-existent facts. They are facts that are already in existence. Simply put, it involves a systematic examining, looking into depth of different sources of information that are already available for use. Now, this information could be laws, it could be text, it could be search engines, it could also be library, it could be law reports. You know, it could be books or non-book equivalent. That means internet facilities that you want to use in arriving at an informed position. That is what a search is. Now, the challenge now is, how do people go about search? If you now have all of these things in place, how do you go about doing a search effectively? It is not enough to gather information. It is better to do it effectively. First things first, you must note that the sources of gathering information can be in two forms. One, it could be through primary sources. And two, it could also come through secondary sources. A primary source is the document itself. It is the law itself, the raw materials itself. For instance, if you're talking about a primary source of law, the Constitution is a primary source. The Evidence Act is a primary source. The laws made by the State and National Assembly are primary sources of law. The laws made by councillors in local government areas, that is the legislative arm, are primary sources of law. International laws agreed to by parties are primary sources of law. Now, the secondary source includes the interpretation of the primary source of law. The interpretation of the primary sources of law are the secondary sources. This includes textbooks, analysis, law reports, and all of that have been done by another person outside the primary source. The secondary source is looking into the primary source, explanations, and all the other issues that go with the primary source. That is, those are the two important sources from which you can get information. Now, it is not enough for you to say you have the information. You must know how to apply it. You must know how to analyze it, and you must know how to come to conclusion. If you have any challenge, the first thing is there is a legal issue, there is a legal concern, there is a legal problem for which you want to resolve. How do you do it? You first of all identify what the problem is. If it's a breach in contract, okay, that is what the problem is. What do you do? Which laws apply to a breach in contract? You go to the laws that generally apply to a breach in contract. You go to the laws that specifically apply to a breach in contract, generally, general application, that's one. You go to the laws that specifically apply, not now to general, but to specific areas that apply to general, applies to contract. The third thing you want to look at are the exemption clauses. If this generally applies and this one specifically applies, in the event of a problem, can your client be exempted? Is there a leeway for escape? So when you are looking at a document too, when you're looking at drafts too, those are the frontline things you want to consider. One, this is general application, this is general rule. Two, these are specific rules. The third one, what are the exemption clauses? You want to look at this, you want to look at those as a basis for resolving an issue. Now, having gathered your law from the primary or secondary sources, as the case may be, haven't gathered the law and haven't looked at their applicability, either as a general application or as a specific application or on the exemption, the next thing you want to do is to see how these laws that you have gathered apply strictly to your particular concern, which is the law of contract, a breach of a breach in the law of contract. What kind of breach is this? What are the circumstances in which this breach will be permitted? Under what circumstances can an exemption apply here? The facts given to me by my client, if put in line with this breach, does it fall under the general rule? Does it fall under the exception specific rules? Does it fall under the exemptions? Or is it, are there statutes outside any of these that will excuse my client? You know, if you in criminal law, there could be reason. Justification is a reason. If you say someone has stolen and truly the person has stolen, the person cannot sue you for defamation. So you look at all of those exemptions. You look at laws that apply in those areas. Now, the third part you also want to look at, since you are dealing with the research, is that industry area. You know, the law applies specifically. It could be contract, it could be divorce, you know, it could be conveyancing, every area. Those areas also have rules that apply to them. Now, you want to look at rules that apply customarily to this particular transaction of breach of contract. Now, you have looked at the law, you have raised the issue, you have sourced for the law, you have looked at the general application, you have looked for the specific applications, you have looked for the exemptions. The third thing in the course of your research will now be to look at the industry rules that generally applies to those areas. For instance, a person cannot go into a contract if the person is less than 18. If you must go into a contract at less than 18, what do? You are supposed to go there either through a person that is older than you, your parent, your guardian, or anybody that is standing in that capacity. Now, you look at those general rules that apply in those industry areas. Now, when you have gotten all of these general rules that apply, the next thing will be to apply them to your client's particular issue, the reason for the research, the concern, the legal issue that is bothering you. the legal opinion that you want to solve that has enabled you to get all of this information. You now apply it to your particular case. Upon application, you'll be able to know whether it fully applies or whether it partially applies. The facts of your case might be unique in such a way that it may not fully apply. If it doesn't fully apply, does it partially apply? If it partially applies, the other part that is left, how do you cover it up in law? Are there exemptions or exceptions that will apply in that case? So this will be the mindset of your research. If it partially applies, you look at that area that it applies in. Now, are there decisions of courts that if put in place with proper distinguishing, your case will still apply? Are there facts in statutes, in laws that have been made that if you look at, it will now cover for those loopholes that are in your case? Are there decided cases which if you look at will not cover for? Are there arbitration resolutions that if you look at can now apply to this particular case? That is what you now look at. Having applied the laws, it will either apply fully or partially. If it applies fully, you are good to go. If it applies partially, you look at the extent of its application partially, and you look at other laws, other statutes, other decisions, other that can apply in the instant case to see how you can resolve the second part. Now, this is what a proper research is expected to do. Having gotten all of this information, the last lap will be to just put up your final analysis, which is your legal opinion, if you wish. If it's a court document, of course, your final resolution, what you are asking the court to do for you. If it's a legal opinion, you are also looking at it and looking at the position of the law that you're giving to your client as an advice. If it is a legal argument, of course, your final argument and decision will now contain these positions. Now, in doing this, there are important things you must note. Your research must be done in language that everybody can understand. It must also be persuasive. It must be logical. It must be reasonable. And all of this you must express in proper and good English so that anybody looking at it will not have any hiccup. I know that there are legal jargons that sometimes are important, but what is most important is the user of the research, the user of the legal opinion. If it's a court, of course, you know legal jargon. If it's an illiterate person, of course, you do it in such a way that the person can understand. If it's an educated person, you also do it in the same way because that is the time that you can say you have done communication. Now, this is legal research. There's the other part that talks about drafting. Before you draft, that means there is an interest you want to protect. Anytime you are drafting, there is an interest you want to protect or an interest that you are fighting against. You are putting information down to capture certain facts that will protect certain interests. That is what a draft is about. Most times, drafts are restricted. When you talk about legal drafting, the first port of call is that it talks about documents, conveyancing documents, wills, contractual documents, and or intellectual property documents, wherein you are clearly defining terms and conditions that applies to the transaction, which is the concern of your client or the basis for the drafting of a document. Now, today I just submitted a deed of conveyance to my client. A deed conveying ownership in land, 3 plots of land to my client. Now, if we use that document as a basis for our analogy, the first goal in any draft is that you have an interest to protect, which is the interest of your client. You must ensure that the interest of your client meets the formal requirements of law. What do I mean? The interest of your client must be properly protected in every document that you are drafting. Yes, the document can take the usual form that is accepted and agreed. It can take the usual form, the usual structure. You will see all of that in different precedents, depending on what you're drafting. If it's a contract, if it's a tenancy agreement, if it's a conveyancing document, if it's a deed of assignment, if it's a deed of lease, irrespective of what you're drafting, the precedents are there for which you can look at. But what is most important, first off, is the protection of the interest of your clients. That one is mandatory. It is non-negotiable. You must ensure to protect the interest of your client. Now, you must ensure that the interest of your client is couched in such a way that there are no ambiguities. It brings you to the kind of language, your conveyancing language or the register that you're going to use in drafting a document must sufficiently protect the legal interest of your client. That is number one. Primarily, it must protect the interest of your client. Now, when you're drafting, there are certain clauses that must be included to do this protection. Some of these clauses can be of general application to that profession. That's number one. Some of these clauses can be specific in that it definitely is specifically protects the peculiar interest of your client. Now, some of these clauses can be industry-based. That means for this kind of industry, these clauses are required to be in place. So one, you must ensure that the interest of your client is protected. Two, the words that you use in protecting the interest of your client must not be ambiguous. Three, the draft in itself must have enforceability. You must be specific with terms, words, rights, obligations. Who does what, when it is to be done, and at what point, if this person doesn't engage in this responsibility, at what point will the person be held liable? Now, first off, your client. Two, his interest. Three, liabilities. And in expressing the interest of your client, it has to be explicit. Your client's interest must be clearly and explicitly protected in your draft, irrespective of what you are doing. And lastly, in the event that there is a breach in your client's interest, you must also produce in that document the consequences. We all know what happens if there is a breach of contract. It's either you sue for specific performance and all of that. But today the world is growing. So they are, instead of going to court, people are looking at ADR means of resolving disputes, or clearly stipulating what should be done, how it should be done, and when it should be done. Timelines, clear timelines for who does what, clear timelines for the responsibilities therein, and also clear timelines for, in the event of breach, what really is going to happen, because the court will look at those as the basis for taking a decision one way or the other if conflict arises. Hello, are we together? Hello?
Yes, we are. We are.
Okay. Now, why I have itemized these issues with the draft is because from jurisdiction to jurisdiction, they have different formats of drafting documents. The precedent of draft differs from jurisdiction to jurisdiction. But what is important are these components: protecting the interest of your client. Now, you can even draft a document in such a way that even when your client breaches the agreement, he is given a soft landing, an opportunity to remedy it before you hit the court. You can either say, in the event that there is non-compliance on the part of your client on an obligation that parties will not head to court initially, parties will be given a period of grace of, say, 20 days. If that 20 days expires, then they can resort to an arbitration, an arbitration panel that will be mutually agreed, because the court usually takes time. So most times people don't subject it to the court. Now, if you are in jurisdictions where there are other mechanisms for resolving dispute outside the court, like in Bayelsa State, we have the multi-door courts, in the one hand. We also have the small claims court. If you're in these jurisdictions where you have this court, you can recommend these other areas where there can be summary trial of whatever conflict as against hitting the court in the first instance. But principally, irrespective of the jurisdiction that you're at, irrespective of the differences in draft documents, what should always ring in your head is the adequate protection of your client, is the adequate definition of who does what, is the adequate definition of when it is to be done. And in the event of not doing it, who takes responsibility and the extent of responsibility of each of these parties. These are the most important decimal that should be in your head. Am I supposed to go on straight, or I'll pause and we take the second part of the lecture? Hello?
Oh my God.
Stella has an issue
Just,
system, so I will take up from here.
just help me.
Okay,
At the
I
moment,
was thinking maybe I finish the second one, then you take the questions.
Sorry.
we'll handle that, sir. But at the moment, I would
Okay.
like us take in the second speaker, considering the time factor, because
Okay, sir.
we don't have so much time on our side. But at the moment,
Having
the
thank you.
second speaker in person of Mr. Olaoluwa Ario to have his own session, after which we'll move to your concluding parts and other remarks. So, Mr. Olaoluwa Ario.
To the next topic, which is so that I'm mindful of time, engage in other topics. All right, Mr. Paraboma, let's go straight to oral advocacy.
Okay.
Thank you, sir.
An advocate is a person that speaks for another, typically representation. Now, for the purposes of this discourse, I think advocacy here is tied to courtroom or legal representation of someone. Now, if you are in the court, first off, the environment dictates the kind of language that you use. You know that it is a legal setting, and so you must use a legal language. So first thing you look out for in your advocating for your client, either in court or out of court, is first the environment. Who are your audience? The way you address the court will be different from the way you address a secondary school principal. It will also be different from if you are appearing on behalf of your client in a board meeting. So the environment is very important. Secondly, you want to look at the language that you will use in the course of advocacy for purposes of communication, being you sending information and the other party receiving it and giving you feedback. It is important you communicate in language that is easy and understandable by the other party. Next is your understanding of the subject matter for which you have been called to advocate. You would agree with me that if you do not understand your client's case properly, you may not be able to put a proper advocacy for him. Each case is unique, so it's not an issue of one size fits all. There could be some peculiarities in this particular issue of advocacy for which you would require to give proper facts in helping, proper facts and proper explanations to help your client. So you must understand the case of your client, whether in court or out of court. It is also advisable that you do preparations before the advocating opportunity comes. That means you prepare for advocacy, because a lot of things will not take you by surprise. How do you do this? If it's a case file, you look at the case file, you study it, you read it down. What are the laws that applies to them? What are the facts that are unique to this case? If there are case laws, you write out the case laws and put them by the side. You write down the case laws and put them by the side. If there are statutes, you write them and put them by the side. There's a saying that the best way not to forget anything is by writing it down in a small place, maybe a small sheet of paper. It will guide you if you're advocating in court. Just a mere glance into it brings you back to speed. So you must study your case. You must know your peculiar issues, because that is the only basis upon which you can do proper advocacy. Now, whatever you say must be convincing. Convincing in the sense that a layman looking at it will see that there is a logical flow or sequence of thoughts in supporting your client's case. If you have a good case and you don't convincingly marshal them out, you may not be able to get the desired result. So the ability for you to convincingly marshal out your case is another component. Now, if you are talking to the court, for instance, you are in court advocating, it will be better you know the court and know the kind of things the court likes, the temperament of the court. Some courts may like legalese, legal jargons. Some courts may not like it. The business you are into, if it's a normal business, what kind of English is allowed or easily understandable around that environment? You also want to use it. Of course, if you're dealing with a mechanic, you will not be speaking Queen's English because they may not understand. I've had to deal with clients that when they come in, although they have a lot of money, when they come in, they struggle with English. And midway, I tell them, Oga, no worry, speak Pidgin. Speak Pidgin. You see them, they are freer in expressing themselves. So even as you talk, you must look at the person you are advocating for, the person that is listening to the advocacy. Are they getting it? If they are not, what can you do? Is it change of language? If it's a physical advocating place, you can also gesticulate respectfully. You express, you maintain eye contact, you say what you want to say, you calm down, you pause, you are not in a hurry. Also of importance is that when you're advocating, you should also look at the audience and know the pitch of your voice. Some people normally, when they are in their element, they shout unknowingly. It's not because they want to do it on purpose, but they just shout because they're in their elements. They want you to hear. If you're in a courtroom, of course, you're not supposed to shout. If you're talking to someone that is older than you, as you are advocating for somebody with another person that is older than you, you are not supposed to be shouting. You're supposed to talk normally. Sometimes you can also get slower if you find that the people are not grasping what you are saying, because some people are stammerers. They can be a bit fast in communication. What do? You slow down the pace, bring it to the pace of the person that is listening to you so that they will get your fact. Be logical, be firm, and be diplomatic in marshalling out your point. Please, at no point should you be antagonistic. Even if the person is not getting you, you express your opinion with due respect. That is why you are called to the bar. Etiquette is part of the discharge of your professional duties. Even if the person you are talking to is an illiterate, what do? You talk to the person in the language that the person would understand with the best of courtesies. Sometimes the courts can even be your enemy. Even in such instances, what do? You do not talk back in pitched tones. The court can even take a wrong position that you are sure of. Even when you want to put forth your fact, you say, with due respect, my lord, our position is, you cite the laws and you cite the authorities, you cite the case laws, either from a primary source or from a secondary source. It will help you if you have done a proper research and you have these things by the side. And most importantly, sometimes the emotion that you are carrying from before you go into the advocacy is also important. A lady that is going through menstrual cramp may have prepared very well, but by the time she gets to court and she's feeling those pains, sometimes she may not be at her best. So you must also work on your psychology. It's possible that you may not also be feeling well on the day you're going for the advocacy. So that can be an intervening variable to affecting your advocating skills. So what do? You prep yourself. Sometimes you can even look at the mirror if you think you can look at the mirror, analyze your advocating skills, look at your face, your facial expression, how it goes. Is it aggressive? Some people's faces are naturally strong. It doesn't mean that they are angry or bad with the court. No. So what do? If you have those kind of appearance? You settle down. You use words that are calmer and soothing. You use respectful adjectives and qualities to address issues. The court will be calm with you, even the person you are talking with. Of course, for guys, you don't go asking out a girl shouting at her. That means you're already losing it. So if you are advocating any position on behalf of anybody, courtesy and respect to the person that is listening to you is important, because if that person does not get what you are saying, of course, you have lost it. And as a legal practitioner, every opportunity to advocate is an opportunity to earn money. So if you misfire, you have lost money, or you have lost a client that might potentially bring other clients. Even rude people do not want other people to be rude to them.
All right. Sorry to cut you short, Mr. Paraboma.
Yes.
Sorry, Mr. Paraboma. We are running against time and we have other topics to watch. So thank you so much
thank you very
for
much.
lecturing us today and reminding us of our advocacy skills. Thank you so much. So without further ado, we invite our next speaker who will take us on some other topics, about 3 topics. So we join me to welcome Mr. Olaoluwa Ariyo. Yeah, Mr. Olaoluwa Ariyo will be taking us first on understanding client needs. And so we'd have him unmuted. I guess he's here already.
I'm already muted, yeah, Stella. Can you hear me?
All right, thank you, sir.
All right.
All right.
Thank you
Have the
very
floor
much.
now.
Thank you. How many minutes do I have?
We have 10 minutes, sir.
10 minutes.
Yes, sir.
Sarah, thank you very much. I also want to thank the NBA Gariki branch for this opportunity to be on the webinar today. Essentially, I've been given the task to touch on understanding client needs and expectation, and also in a way to speak about client interviews and also case management. So, because of the time that has been allotted to me, I will only touch on them as per overview, basically, so that I don't go beyond my allotted time. All right, so understanding client needs and expectation. The first thing I would want every one of us to always keep at the back of our mind is that the legal practice is a service delivery venture. It's a service delivery venture. What that simply means is that we have the commodity that we trade is in rendering service to prospective clients. And prospective clients always place their orders, and it is what they order that we have to serve them, basically. And how we manage them, how we manage the product we sell to them, how we take them through the journey of the entire legal process will determine whether we can retain them or whether we lose them at the end of the day. So basically, the first thing that needs to come to the mind of every lawyer who intends to be able to reach out to the heart of a prospective client is to first and foremost um, own the skill to be able to penetrate the mind of the client to know what exactly, to decipher exactly what their desire is for approaching or engaging a lawyer. And of course, that will only um, be harvested if we are able to deploy certain legal skills in terms of first and foremost, try to be patient to understand, try to be in a way also activate actively listening, also trying to decipher in terms of the legal details that are embedded in the issues that have been presented. So basically, it takes a lot of patience. In practice, when a client comes, it takes a lot of patience to be able to understand the client, because again, you have different classes of clients. There are some clients that are very brash. There are some that are emotional. There are some that are perhaps hot-tempered. Different personalities will always come to you. And because of the kind of trade that we are in, there is no time for you to begin to say, I want to sift this kind of client. I don't want this kind of client. If you do that, you are going to lose a lot of money. So basically, we must be open-minded as lawyers to receiving whatever personality in terms of the client that we have. And essentially, also, we must learn to build trust and satisfaction. We must learn to build trust and satisfaction. When they come to us, the first thing we must sell to them is the fact that they can trust us, that we can also meet their needs. Of course, not over bloating performance in terms of what you can do or deliver to them, or what you will do even outside the length of the law. That's not what I'm saying. But trying to give them the assurance that they can repose a measure of trust in you, and trying to give them that legal satisfaction is very, very key. Again, also, how you are able to manage their case effectively also matters a lot. How you manage their case effectively from the point of interview all through to the point of engagement, doing what you need to do in terms of addressing their legal issues, and even wrapping the entire thing up and arriving at the desired and agreed satisfaction. that they came to you for. All of those entire process will determine whether you can sustain trust and also have in a way satisfied what they have come to you for. Basically, I will just touch again on the second issue, which is the issue of client interview. Once you are able to arrest the mind of the client in terms of what they come to you for, to be able to thoroughly decipher what their legal needs are, you have to conduct a client interview. Because of time, I won't be able to run through step by step, or maybe if there are questions, I may be able to touch or elaborate on them later on. But of course, you have to prepare yourself mentally before they show up in terms of physical meeting or even in terms of virtual meeting. Ensure that there are no distractions. Ensure that you have an atmosphere conducive for active listening, essentially. Ensure that your notepads are ready. Ensure that you don't have any biases in your mind. You are not mirroring your clients based on your own experiences or based on the experience you've had with another client before. So you have to declog your mind, essentially remove every form of biases and ensure that the grounds are made ready, the atmosphere is made ready for them in terms of client interview, because only in that way you sit them in a comfortable atmosphere where they can express themselves, they can open up to you, because that is really what you want. You don't want a situation where your client only discloses or gives you partial disclosure with respect to the circumstances that has led them to you. So you want them to be relaxed. You want them to be able to open up to you at least to 90%, 100% degree to enable you understand the full spectrum of what is happening with them and how to provide the requisite legal services. And then the last one is about case management. Once you have received the client, once you have deciphered their legal issues, once you've heard them, once you now know the legal options that are presented to you, the next thing is to begin to activate. For example, if it's a litigation matter, which court to go to, briefing the client, letting the client understand the peculiarities of our legal landscape, our court system, envisaging how long the matter may take, and spelling all of those things out, and managing their emotions and expectations, letting them know once you go to court what happened in court. Clients don't like to be the ones reminding lawyers to give them updates. That infuriates them a lot, and that can damage trust and confidence. So it is important for us to cultivate I would say, the discipline of updating our client, even if it's just about conducting a search on their behalf. Don't wait for them to be the one to remind you before you actually put up that update to them. It cultivates a lot of trust and some form of it strengthens your relationship with them, basically. So I will just stop here because I can see Stella is about to motion me to begin to round up. But if there are other questions, then I can expand on some of the things that I've touched to just shed some light on it. Thank you very much. That's my overview for the three subjects. Thank you.
All right, thank you so much, Mr. Rio. I was going to first say you should please turn on your camera so we see your face. And then remind you that you have about 3 minutes. 3 minutes to round up. Yes.
Okay, can you see me now?
Thank you so much. Not yet. So if we have any questions for any of the speaker, we can just drop our questions in the chat. Thank you. Can anyone see Mr. Rio yet? I can. Okay.
I think you have some questions in the chat box already. You should check the chat box. There are questions there.
My video is very, very much open and live, same as my voice.
I can hear you clearly. We can see your face. Thank you, sir. So you can just round up in 2 minutes. Thank you.
All right. So thank you very much for the 2 minutes. I will take it So basically, client satisfaction should be the prerogative of every lawyer. And that is what all of those three steps in terms of understanding clients' needs, which is very, very paramount. There is no way you can provide any form of legal solution to any client you have not thoroughly analyzed their case, their predicament, or what they intend for you to be able to help them with. And also, once you make an attempt at that, that leads you to client interview. Client interview is basically the space where you are able to harvest every necessary details, information that is required for the legal positions you want to take, the legal steps you want to take in addressing the need of the client. And once that is ticked off your box diligently, skillfully, then we move or migrate into case management, where we begin to take the necessary legal actions in trying to address all of those issues. And like I said before, trust is very key in this our enterprise, in our legal enterprise. Trust is very key. If there is going to be any referral that is going to come from any client, it is based on trust and satisfaction. If they are not satisfied, there is no way they will refer you. In fact, if your name pops up around them, they will try to dissuade people from engaging you. So our selling point is actually number one, trust. Number two, client satisfaction. And I would also add that that we must be diligent in anything that we do. We must be very, very thorough, which means we must pay all necessary attention. We must deploy every necessary energy and also the requisite skill and expertise that comes with our service delivery must 100%, if not 150%, deployed for every single client. And meanwhile, if you are in a busy law office, for example, there is a tendency that you are going to be distracted from some matters or some cases. Every client, it should be of utmost priority. Don't prioritize some above the other. That would be hypocrisy in your trade. So you must learn how to multitask. You must learn how to prioritize every client. Every client must see you as, they must see themselves as priority to you, not based on the money they are paying you, your retainership, and all of those things. Deploy the same energy, deploy the same attention, deploy the same expertise and skills, and I know that you will go places. Thank you very much. That will be my 2 minutes.
Yeah, thank you so much, Mr. Rio. We have been blessed and entertained and enlightened with all the things you shared with us today. Thank you so much.
Glad you
So, if you
asked.
have
Thank
questions
you.
for either Mr. Ario or Mr. Parabuma, let's just drop them in the chat. Let's drop. We have a few questions already, or they are directed to Mr. Parabuma. So, without taking so much time, we'll just go straight to questions and answering. So, um, the first question is for Mr. Paraboma. I hope I'm pronouncing your name rightly. I apologize if I'm not pronouncing it well. Please, Mr. Paraboma, kindly unmute your mic and turn on your camera so we can also see your face. Thank you. Yes, sir. Okay, so the question is, what are the advantages and pitfalls in adopting artificial intelligence resources in legal research? What are the advantages and pitfalls in adopting artificial intelligence resources in legal research? So that's for Mr. Paraboma. So you can
Okay,
unmute yourself. Thank you, sir.
I've unmuted myself. Can you hear me?
Yes, sir. I would appreciate if you turn on your camera as well, sir. Yeah, thank you.
Am I?
We
Can you
can't see
see me
your
now?
face. No, not yet.
Okay, I'm trying to do that right away, but I
Maybe the
can't
camera
seem
is
to.
turned backward. I think your camera is turned backward.
Okay, my camera is backward.
Yes, sir.
Just give me a few minutes. I don't have my
All right,
glasses
sir.
on, so it's a bit of a challenge for me now.
Oh, so sorry, sir. Well, you can just proceed to answer the questions.
Okay. Can you see me now?
All right, thank you. Yeah, perfectly well, sir.
See better?
Yes, yes,
Okay.
sir, it is. Thank you, sir.
The importance of the pitfalls rather of using artificial intelligence in legal research. Now, artificial intelligence can at best give you the general principles that are applicable. It will give you the general principles. It will list out the principles. It might direct you to some sources. But for purposes of specificity, you might need to go back to the real law. That means the primary sources or the secondary sources or case law, as the case may be, to be convincing enough for a Nigerian court or a Nigerian case, unless, of course, you are dealing with international correspondences or international transactions. You can do that. Artificial intelligence will give you the right principles. This is what you are supposed to do. This is what you are supposed to do. This is what you are supposed to do. But it will not hit the nail specifically on the head, on the exact case law or the exact primary source of law that you would need, to convince our court in the event that you are dealing with our own courts over here. You still need to go look for that Supreme Court authority. You still need to go look for that exact portion of the Evidence Act, or maybe the laws of the state that applies to that particular rule. So while it is good to get the principle, putting it in proper perspective in line with the provisions of our law will require an extra task that you must do. You cannot escape that bit.
All right, thank you so much, sir. The second question seemed to be similar to the first, but then I'll still throw it out to you. So the second question is, how can we avoid plagiarism in adopting AI sources? How can we
Now,
avoid plagiarism in AI sources?
Now, there are a lot of tools, online tools, that can be used to determine whether a content is of artificial intelligence. In fact, in some schools, when you do thesis and research, you need to screen for plagiarism. Plagiarism is a thing you need to screen for. There is a specific requirement in universities now that if you must submit your work, you do your thesis, you screen for plagiarism, AI, ChatGPT, and all of the other artificial intelligence components that are now trending online for purposes of research. Now, what you can do at best is to get the central idea from artificial intelligence, but you must convert it into your own writing. You must convert the line of thought. You can at best sieve the line of thought and create your own content. By so doing, it moves you from the confines of plagiarism to originality. The thought is yours, the understanding is yours, the scripting is yours, but the principle can come from that area. But if it's for academic purposes, it is now pretty difficult to discern. Now, secondly, one of the challenges of artificial intelligence is that it may not hit the nail specifically, especially when you are given materials to look at. If you are given specific documents to look at, you might look at artificial intelligence and get the general overview, but it may not specifically hit those materials that you have been given to assess. So that might also be another challenge. So while it is good, the best way to check plagiarism is in two ways. One, you will be caught if you plagiarize using artificial intelligence, because there are now machines to look for it and fish you out. But secondly, you can take the principle from artificial intelligence, but when you are using it, you convert it to your own words, to your own thinking, to your own understanding, making your own mental input and adding it to what you may have gotten from artificial intelligence. If not, you will always fall short of plagiarism.
All right, thank you so much, Mr. Paraboma. Thank you so much. We appreciate your
Stella,
response.
Stella,
So we just,
Stella.
yes,
Yeah, I was just, Mr. Barrister Paraboma, I was just wondering that in our legal space now, who is going to be checking my pleadings for plagiarism? I'm just asking. If AI had prepared my pleadings and my thoughts were infused into my questioning or my query, and then AI brings a very robust, say for example, written address, is the judge of the Supreme Court going to be considering whether it is plagiarism when applied on all the points of law?
Yes, you'll be shocked that the judges are also AI compliant, artificial intelligence compliant.
True.
In fact, some of their research assistants ensure that it is not content that are vomited from artificial intelligence. Some of them even screen this work for AI intelligence by themselves. That is if it has to do with courtroom practice. That's what I mean. That is if it has to do with courtroom practice. Now, if it has to do with academic environment, of course, there is no way you would escape it. Maybe for international businesses, using AI is a mundane practice because most people, before they even do anything, they even screen for AI to be sure if it's a product of your intellect, that means your intellectual property, or you have just regurgitated what you got from AI.
All right, thank you, Mr. Barabuma. Time is almost up against us, so we just go straight to Mr. Rio. You have a question to be answered. So, Mr. Rio, can we have you back? Yeah, thank you so much, Mr. Barabuma. So, Mr. Rio, you should unmute yourself now. Yeah. So, your question is: at what time do you carry out a profiling on a client in order to serve the client better? At what time do you carry out a profiling of a client in order to serve the client better by tailoring the client's need? So that's for Mr. Arijo. Okay, I'm muted already.
Yes. All right. So for me, I wouldn't say profiling in a negative light because we are very, very used to using profiling in a negative light. But in terms of, I would say, understanding the client's peculiar needs and then tailoring a bespoke legal service, I will put it that way. Bespoke because it's tailored specifically to the needs of that particular client. And I would say as early as you engage the client in terms of maybe the client interview, once I start to listen to the client, once the legal issues are beginning to pop up, then I begin to take my note for that particular client. All right. Again, like I said before, try not to come to a client interview with biases, whether based on strengths or weaknesses of experiences past. Every new client are important and they are as fresh as they come. So always pay attention to that fact. And from the point of engagement, I beseech you, begin to tailor the solutions, the legal solutions to their specific needs. That's where profiling should start, I would say. If you miss it at that point, it will be too late when you get into case management, because at the point of engagement, all their vulnerabilities are out, all their strengths are out, all their emotions are out, all the necessary questions that needed to be asked are asked. But if you want them to tell you the whole truth, nothing but the truth, is at that point. So profiling should start as early as client interview, I would say. Thank you.
All right, thank you so much, Mr. Ario. So with I guess that's the last question we have from the chat. So today we've covered a whole lot, and if anyone is here today, and especially for those just joining us, and they didn't get anything from this conversation, it's been a very insightful conversation. You should go home with the fact that you should have an open mind with your clients, have an open mind to receiving clients, no matter how they look, no matter what their social profile may be. And then your focus should be on building trust and satisfaction. So we can take that home if we didn't learn anything from today's conversation. So I want to appreciate all our speakers. You guys have been amazing. So with the question and answering, we'll come to the end of our today's session. So I'll hand over the mic to Mr. Justice Oga, our host, to give us a closing remark. Thank you.
Thank you. Thank you very much, Tel. I truly appreciate it. I want to appreciate the speaker for today in person of who is a part of more and more adults. We appreciate you for coming today. Also, Mr. Bongo Faraboma, was the SYL chairman, Sabah branch in Bayelsa State. I made the error earlier. Bayelsa State. And I also want to appreciate the chairman in person of Mr. Bamidele, the publicity secretary as well of the Gariki branch, in person of Damilola Victoria. She has been the voice we hear in the other female voice in the background. And also appreciate ever while in person of Wilayat Yari. She wished to be here, and she actually did. Every other person was present, or is present rather, today in this webinar. So with that, I've come to the end of the webinar. We hope to see you in the next webinar, which is going to come. Okay, there's yet to be a date on that. So we are going to have another host, and I pray that you all be there to witness the next webinar and be ready to learn. Welcome, open mind. Much support from us. I remain Justice Oga, the Assistant General Secretary of Wildlife Gariki Branch. Thank you very much.
Thank you.